This is Lisa Miller and Associates, Florida Insurance Roundup, your podcast on the people, issues, and regulations shaping Florida's insurance market. Now, here's Lisa Miller.
Welcome, friends. We started the 2019 Florida Legislative session in March, believing that this was the year that consumers could finally get relief from assignment of benefits, or AOB, abuse and fraud. Florida lawmakers heard countless stories from policyholders across the state who have been victimized by the innocent-sounding AOB pitch from repair vendors where you simply sign over your insurance benefits and we'll take care of everything. It's been anything but innocent too much of the time, and our loyal podcast listeners know all about this problem from our past episodes. This year, the homeowners' pleas finally resonated with lawmakers. The legislature responded with new rules to beat back these bad actors, contractors and their attorneys who prey on the unsuspecting public, many times the elderly, and the insurance companies that insure them. It passed an AOB reform package that the governor has said he will sign. We're going to hit the highlights of what these new rules do and the protections that they offer, and what they don't do. Our guests on today's program are going to explain the benefits and other impacts AOB reform is expected to have on both consumers and the insurance industry, and what some crafty plaintiff attorneys have already been doing to counteract those benefits in a desperate effort to maintain their one-way attorney's fees for as long as they can. We will still be susceptible to their shenanigans, unfortunately. Joining us from St. Pete is Kim Salmon, an insurance defense attorney with the law firm of Groelle and Salmon. She and her attorney husband, David Salmon, the dynamic duo as I love to call them, have handled thousands of these AOB cases on behalf of insurance companies and their policyholders. And joining us from Fort Lauderdale is Paul Handerhan, Senior Vice President of Public Policy for the Florida Association for Insurance Reform. FAIR, as the acronym it goes by, promotes citizen education and especially mitigating property risk through smart renovation and rebuilding, as opposed to construction ripoffs. Paul also has been a public adjuster and is very experienced in that field. Kim and Paul, welcome to the Florida Insurance Roundup. Let's start by hitting the highlights of what this recently passed legislation does. Paul, you and FAIR have worked tirelessly on this over nearly 10 years. Would you please do the honors and tell us what this new law does?
Sure. Thank you, Lisa, for having me be part of your program today. House Bill 7065 actually is broken down into three major components. One of the areas or the reforms talks about provisions that must be inside an assignment agreement. Another section talks about what assignees must comply with when they operate under an assignment. And then thirdly, what insurers must do when an assignment is executed between an assignee and assignor. So one of the required provisions within an assignment agreement is the rescission period. This bill, House Bill 7605, requires an assignment agreement to have a rescission period of at least 14 days. And if the work is not substantially completed, that can be extended to 30 days. That's a dramatic improvement upon the way that the assignments worked in the past prior to the passage of this bill. Literally, there was no statutory requirement for any rescission period within an assignment agreement, meaning that if a policyholder in the middle of the night, based on some type of emergency service, and they signed an assignment of agreement, they would effectively have no way to rescind the contract. With this new law, you now have the 14 days at a minimum, but up to 30 days if substantial work is not completed by the assignee.
Paul, that is amazing. And I know how hard you worked on that with many of the others that were educating policyholders, because you've seen the abuses out there, haven't you?
Well, I can tell you that a policyholder, if it's in the middle of the night and they've had a major water loss in their home, the last thing that they're thinking about is reading the fine print of a contract. Mm-hmm. What they want is they want somebody to come out. They want to get the water out of their house. They want to get their structure dried, and they'll pretty much sign anything at that point to go ahead and get that work completed. So this at least gives them the ability, if they've signed something or they've entered into an agreement with somebody that they feel does not have their best financial interest, they have the opportunity to rescind that agreement. Of course, they will still be obligated to pay for the work that was completed before the rescission.
Well done. That's great news. Why don't you continue and tell us the other good parts of this bill?
Sure. An assignment agreement has to have a notice of disclosure. Basically, what we would see in practice prior to this legislation being passed is you would have a contractor come out and say, just sign this agreement. Don't worry about it. We're going to bill your insurance company directly. But I don't believe that most policyholders really understood that they were assigning their policy and their benefits over to this contractor. This requires now within the contract a disclosure that's codified in statute that explains to the policyholder exactly what they're doing when they sign this agreement.
And what has to happen once an AOB is signed? Does it have to get to the insurance company in a certain amount of time?
Sure. As soon as that agreement is executed, the assignee has 3 days that they need to send that contract to the insurance company for it to be valid.
Got it. And does it have to be specific? Tell us more about what that assignment does. And when you say assignee, you mean the vendor, correct?
Correct. The assignee would be the contractor who is providing the assignment agreement to the policyholder or the assignor. There is also a requirement of a provision that not only do they have to submit the agreement to the insurance company with 3 days, but as an addendum to that agreement, they need to provide a written, itemized estimate of damages for the work that they're going to do. And the assignment under this law that was passed requires that the assignment be limited to the actual work that's going to be performed.
Wow, that's incredible. And so basically, the vendor is standing in the shoes of the policyholder, and part of the provisions that I read in the bill and that we worked on was that if they're standing in the shoes of the policyholder, then they need to do what the policyholder policy says, like, submitting to an examination under oath and filing a proof of loss and those things. So really, really good stuff in this bill. And Kim, I'm going to turn it over to you. Now, you've heard all these great things and how incredible it is, but the piece we left out was for you, and that's to discuss how the attorney's fees provision has been revised and will help us with the advent of what we currently are under with attorney fee provisions. Kim?
Yes, thank you, Lisa, and thanks for having me join you today. Currently, when we go to court, these lawsuits by vendors, if the vendor wins by $1, they're entitled to attorney's fees under the one-way fee statute. After the enactment of this bill and this law, they're going to be restricted as to what they can recover. Under this bill, if the disputed amount, and the disputed amount would be, I think Paul referred to the notice that the vendor has to give the insurance company before instituting a lawsuit, and that notice has to actually include a pre-suit demand. Within the next 10 business days, the insurance company has an obligation to respond to that notice with an offer. So the difference between the initial demand and the insurance company's offer is referred to as a disputed amount. Now, at the end of the lawsuit, when there is a judgment, if the recovery by the vendor is less than 25% of the disputed amount, the insurer is entitled to attorney's fees. Mm-hmm. If the recovery is between 25 and 50% of the disputed amount, neither party is entitled to fees. And then if the recovery for the vendor is over 50% of the disputed amount, then the vendor is entitled to fees. That's going to have a pretty big impact on the industry.
So, Kim, the wonderful description of how this works and what the law says, what are the practical implications of this, what I'll call the attorney fee formula?
I think the practical application and implication of it is that it's going to enable the insurance company, by the tools that it gives them and by the time frames that it prescribes, an opportunity to actually evaluate the scope and cost of the repairs, of the damage, and it actually incentivizes both the insurance company and the vendor to resolve the matter as fairly and quickly as possible, which, as you know, is going to be a direct benefit to the consumer. So it's win-win.
Kim, that is an amazing description of this attorney fee formula, and we all know that another game changer is the provision in the bill that limits these emergency service repairs, emergency service response to $3,000, or just 1% of the total coverage A of the policy. So this is a comprehensive list of reforms that I think will make a difference. So, Paul, let's kick it over to you for a minute. There's chatter in the marketplace. You've got one mold mitigator saying that this is actually going to increase litigation because there's going to be a window of time from the first notice of loss to the handful of days that the insurance company has to inspect the property, and that's going to, let lawsuits develop. I've seen another YouTube video where another, I'll call him a bad actor, is encouraging people, file as many lawsuits as you can. So, Paul, give us your opinion of some of these concerns and some of these antics and what do you think is going to happen in the coming days and weeks?
There has been some emails and some blogs that have been passed around, and you referenced within the House Bill 7065, the insurance company has to inspect the property within 7 days. There's a caveat to that. It says that the insurer should inspect the property within 7 days, but if they don't, what would happen is they may not be entitled to collect attorney's fees if the case winds up going to litigation. It doesn't say anything about having any other violation other than the fact that they may not be able to collect attorney's fees. So that, I don't think in itself that would be a cause of action if they did not inspect the property within 7 days. There was also some talk about the insurance company having to adjust the loss with accepted industry standards. Mm-hmm. But if you carefully look at House Bill 7065, when it talks about accepted industry standards, it refers to the assignee. And it says that the assignee, which is the vendor, when they go out and perform work for the policyholder, that their work has to be done with accepted industry standards. Some of the stakeholders out there are referring to accepted industry standards as IICRC standards, but the legislation itself actually doesn't refer to that standards. And there's several standards out within the industry, and some of which actually conflict with IICRC standards. So there's some ambiguity there. The way that they're reading it, I don't think is a proper reading of the legislation. So I don't think that there's a tremendous amount of risk there for the insurers. It seems like most of the obligation is on behalf of the assignee themselves.
Very good perspective. And so, Kim, I'm going to go back to you because, when you hear the word ambiguity, your world is made up of clarifying ambiguity and challenging it. What do you see this bill is missing? What do Paul's telling us what he what may be happening in the next coming weeks. What do you think, and I hate to put it this way, but what's the next scam? What are we going to be facing in the coming weeks with people, quote, figure this out and go in another direction?
Well, a couple things. I'm glad you asked that question, Lisa, because first of all, one thing that this bill does have is it creates conditions precedent to filing suit for the vendor. One of those conditions, in addition to examination under oath and recorded statements, is if appraisal is demanded and if appraisal is in the policy, the requirement before suit for the vendor to go to appraisal. But I would caution insurers to beware of that condition precedent. Although appraisal is binding and it seems like a good way to resolve a dispute under this statute, remember that the statute says that for purposes of these post-loss benefits, the vendor is standing in the shoes of the insured. And if so, what we don't read about in this statute is whether or not an insurer has exposure under the bad faith statutes. So under current case law, Camerata and most recently the Bryant case versus Giovera, it looks like an appraisal award could trigger the right to file a bad faith suit. And under the wording of this statute, the question is, does the vendor have those same rights? So I'd be very cautious about the language in an insurance policy if there's a unilateral right to demand for appraisal. The other section that I see as some potential exposure would be under 11B, where the statute or the bill says that a power of attorney that grants a management company, a family member, a guardian, or someone else similarly situated the authority to act on behalf of an insured as it relates to the claim, so that possibly with a limited power of attorney, someone in that position could file a lawsuit on behalf of the insured. So that would be really a way around the protections that were intended in all the work that went into this bill.
And to that, I say, for the creative lawyers that have been preying on consumers and causing this insanity, and if you're listening to this podcast, I would caution you that the legislature was listening to consumers complain about this, that have been victimized by the use of an AOB and the resulting litigation explosion that has occurred because of it. And I believe that any attempt to thwart the intent of this legislation will be dealt with summarily in the coming session that starts in January. So as we wind up the close of this podcast, I do want to talk real quickly about the Florida Supreme Court and what's going to be happening there, we believe, in the next quarter, maybe 4 or 5 months, with a conflicting couple of DCA, District Courts of Appeal, opinions. So, Kim, if you can just quickly talk about that particular Supreme Court pending case.
Lisa, I think that the Supreme Court has had the benefit not only of understanding the landscape that we're dealing with right now through all the proposed legislation and through the efforts connected to this bill, but through the amicus contributors that, have weighed in on this Groelle case. I think every reason to believe that the court, in light of everything they've seen thus far, will uphold the Groelle decision. I'm very hopeful and confident.
That's great. And that is the decision that the dispute that allows a mortgage company to weigh in and have a say about an AOB or not. Is that correct, Kim?
Absolutely. That was the language in Groelle's policy that required just simply all parties at interest to sign the assignment of benefits, to agree to it.
Great.
For it to be valid.
That's incredible. And Paul, if you can just give us some closing thoughts. You, of course, are a very honorable public adjuster. You work with consumers all the time. You advocate on behalf of consumers. You talk to insurance companies. What will you be doing over the next quarter or so to educate your readers and leaders about this issue?
Well, I think it's important to understand, too, that this bill still preserves the right for a policyholder that's in a dispute or winds up having to go into litigation with their insurer to be able to collect their attorney's fees and costs. So there is still a remedy for policyholders when a dispute exists for them to get redress from an insurer if they should have paid and then the policyholder winds up prevailing in that action. I think the big distinction that should be made between a policyholder bringing an action against an insurer and an AOB vendor. Typically, in a lawsuit, an insurer will offer what's called an offer of judgment or a proposal for settlement. If you're a policyholder and your insurance company provides you with an offer of judgment or a proposal for settlement, and you reject that settlement, and you don't get a certain amount of percentage over that amount, the policyholder can be responsible for the insurance company's fees and costs in that scenario. And many times policyholders, they have assets, they have their home, they have other things that could put them in financial risk. So they tend to be a lot more reasonable when they're trying to get their cases litigated through the courts. An AOB vendor, what we saw many times, were not very much willing to come to the table and try to negotiate a reasonable number, because they were pretty much judgment proof. The company didn't own any assets. They were just, they had a corporation, and if they wind up getting a judgment against them, they could just cancel that company, open up another company, and continue their business. So this actually, I think what you're going to see, it may not lower the number of frequency in lawsuits, but I think the reasonableness to get cases resolved when they are litigated will be much more beneficial when those suits are being brought by policyholders rather than the AOB vendors.
Well put, Paul. I really appreciate both you and Kim being on the show. And in our podcast show notes, for those of you that follow our work, we'll have links to kind of our entire comprehensive end of session bill watch from our newsletter. For those of you that don't subscribe, we encourage you to go to our website, lisamillerassociates.com. You'll see there our assignment of benefits webpage and all kinds of information for you as you go through your daily work, either in an insurance company or in other areas. And we want you to do a deeper dive into this AOB reform bill. We'll have the bill, a link to the bill there. You can read it. It's only about 16 pages. It's easy to read. We'll also put links to Paul's great organization, FAIR, and their website, and of course to Kim's prestigious and brilliant law firm, Groelle and Salmon, and even a summary of today's conversation. So basically, we take all the notes so you don't have to, and we want you to, like this podcast out in social media and share it with your colleagues. My work in the field is like working with family. I've worked with many of you close to 20 years, and it's been a great privilege. And if you would, let me hear from you. You can call us, leave your comment or question. We'll get back to you just a bit later. You can actually just give us a buzz at 850-388-8002. That's 850-388-002. Or you can just send me an email. Most of you that work with me know that I'm 24/7 and I love the input. Lisa Miller at lisamillerassociates.com. Lisa Miller at lisamillerassociates.com. Paul, thanks for being here.
Thank you for having me.
And Kim, my regards to David and your great work. Thank you.
Thank you, Lisa.
That's the Florida Insurance Roundup. Thank you for being a part of this. Remember, at Lisa Miller & Associates, we have a passion for policy and client success. I'm Lisa Miller. I'll see you on the trail. Be safe.
This has been Lisa Miller & Associates Florida Insurance Roundup, your podcast on the people, issues, and regulations shaping Florida's insurance market. For more information on today's program, please visit us on the web at www.lisamillerassociates.com.